Good afternoon, everyone. My name is Victoria Santoro. I'm the president of the Massachusetts Bar Association, and it is my honor today to welcome everyone to the live webcast of the State of the Judiciary address. The format today, as you'll see in just a few minutes, will be a panel discussion after some opening remarks from Chief Justice Kimberly S. Budd. Joining us for that panel discussion are, of course, Chief Judge Heidi S. Brieger and Trial Court Administrator Thomas Ambrosino. But before we get started, it's also my honor and pleasure to thank everyone involved in putting together this collaborative event, which has been going on for many years now and in various forms. The purpose of today is, of course, to give a report on the status of things in the Commonwealth, but also to celebrate the State of the Judiciary address as one of many examples of successful, long-term bench bar collaboration. A couple of examples to highlight today of our bench bar collaboration in the Commonwealth of Massachusetts. First and foremost, the Superior Court Lawyer for the Day program. This program is put on through Zoom statewide in every Superior Court in Massachusetts. We are, through this program, working together to help people who might otherwise fall through the cracks in civil cases that are pending in Superior Court. This was the idea of the Honorable Valerie Euratius, and an idea that was championed by Chief Judge Heidi Brieger, who's sitting here today. The pilot program started in Middlesex Superior Court, and last year was expanded statewide, and it is up and running every week currently. Lawyers can visit the MBA site if they're interested in volunteering. We are always looking for volunteers. The MBA is proud and grateful to also collaborate with courts on other successful programs aimed at introducing students from underserved communities to opportunities in the legal profession. First among them, the SJC Judicial Youth Corps, and the MBA's Tiered Community Mentoring Program, where I very proudly serve as a mentor in Worcester, Massachusetts. We are so grateful to our court leaders for the paid internships in the courts given to some of our Tiered Community Mentoring students over the last few summers. We are also so proud to follow the court's lead on matters of lawyer well-being and diversity, equity, and inclusion. Looking ahead to January, next month is another long-term successful collaboration: the Walk to the Hill for Civil Legal Aid. This important event will take place on Thursday, January 23rd. It is presented by the Equal Justice Coalition, the MBA, and the BBA, and is supported by court leaders. Join us and help advocate for additional legal aid funding in the Commonwealth. The bench bar collaboration in Massachusetts remains as strong as ever. We know our courts are busy making tech enhancements and other improvements to courthouses around the state, and the MBA remains your steadfast partner to defend the rule of law and promote access to justice. Now it is my honor to introduce to you, for some opening remarks, the Supreme Judicial Court Chief Justice Kimberly S. Budd, who has been a trailblazer throughout her professional career, and very particularly for Black women and attorneys of color. On December 1st, 2020, she made history when she became the 38th Chief Justice and the first Black woman to be sworn in as the Chief Justice of the Massachusetts Supreme Judicial Court. She was initially appointed to the bench in the Superior Court by Governor Deval Patrick in 2009. She eventually became the Regional Administrative Justice for Middlesex Criminal Business in 2016, before being elevated to the SJC that same year. She is a graduate of Georgetown University and Harvard Law School. She has taught trial advocacy at Harvard, formerly taught at New England Law Boston, and teaches at MCLE and Bar Association programs. Just some of her many notable lawyer roles included law clerk to Chief Justice Joseph P. Warner of the Massachusetts Appeals Court, litigation associate at Mintz-Levin, an assistant U.S. attorney in the U.S. Attorney's Office in Massachusetts, and director of the Community Values Program at Harvard University. Chief Justice Budd is a proven and respected leader who has been a vocal advocate for equity and fairness for all. She continues to inspire all of us in the Commonwealth, and we look forward to continued collaboration with her and other court leaders. I'm so proud to introduce SJC Chief Justice Kimberly Budd.
Thank you so much, President Santoro, for that kind introduction, and thank you for taking part in our program today. I also want to thank the guests that we have here from the NBA, President-elect Michael Hayden, Vice President Sam Siegel, Treasurer Shayla Mumbler, there she is, Secretary Mark Mocha, the NBA's longtime Chief Legal Counsel and Chief Operating Officer Marty Healy in the back there, and Director of Policy and Operations Lee Constantine. And I also see we have past presidents, Grace Garcia and Damian Turco. Welcome to you as well. On behalf of the entire Massachusetts court system, thanks to all of you and to the Mass Bar Association for supporting this event. The NBA and other bar associations play a critical role in sustaining our legal system through mentoring your members, supporting pro bono programs in public service, encouraging civic engagement, and supporting the courts in so many ways. As just two examples, we deeply appreciate the NBA's development of a virtual Lawyer for the Day program in Superior Court, as well as the Mass Bar Foundation's support of the Ralph D. Gantz Judicial Scholarship Program, which provides stipends that enable law students with financial need to accept unpaid judicial internships. We're so grateful for all that you do. I also want to take this opportunity to thank Governor Maura Healey and Lieutenant Governor Kim Driscoll and our legislative leaders, including House Speaker Ronald Mariano, Senate President Karen Spilka, the Ways and Means Committee co-chairs Representative Aaron Mikowitz and Senator Michael Rodrigues, and the Judiciary Committee co-chairs Representative Mike Day and Senator Jamie Eldridge. All of them have strongly supported the judiciary. They make our work possible through annual appropriations, authorization of additional judicial positions when necessary, and funding for special projects such as the IT bond bill that's enabling us to upgrade technology across the court system. I also want to thank Governor Healy and Lieutenant Governor Driscoll and the members of the Governor's Council for the appointment of two new members of the SJC earlier this year, Justice Elizabeth Dewar and Justice Gabrielle Wolahojian. We are so pleased to have them join us. In addition, I want to express my appreciation to Trial Court Chief Heidi Brieger and Court Administrator Tom Ambrosino for their terrific leadership of the trial court and for participating in this program today. And I am, of course, grateful to all of my colleagues in the judiciary for their teamwork and dedication. Many of them are here today, I see, including my colleagues from the SJC, Justices George and Dewar, and Trial Court Chiefs Gordon Piper of the Land Court, Diana Horn of the Housing Court, Tracy Lee Lyons of Boston Municipal Court, and Michael Ricciuti of the Superior Court. I think I have everybody. And finally, to all of you in the audience and watching online, welcome, and thank you for joining us. So we have a lot to talk about this afternoon, including transitions in court leadership, improvements in court technology and security, significant rule changes, and some ongoing projects to increase the efficiency in case management and better support litigants who cannot afford counsel. But first, I'd like to take just a few minutes to address another overarching issue that's essential to our success and the success of our legal system: the importance of maintaining public trust and confidence in the courts. Alexander Hamilton famously called the judiciary the weakest branch of government. We wield no power of our own, but for the power that others give us by respecting our decisions. Unfortunately, today there are serious signs that respect for the courts is declining across the country. I'm a member of the Committee on Public Engagement, Trust, and Confidence of the National Conference of Chief Justices and Conference of State Court Administrators. In August, our committee reported that in annual polls conducted for the National Center for State Courts, the percentage of people who believe that state courts provide equal justice for all well or very well has declined from 62% to 46% in the last 10 years. As you might imagine, the problem isn't limited to state courts. According to Gallup, the percentage of people reporting that they have a great deal or fair amount of trust and confidence in the federal judiciary has fallen from a high of 80 in 1999 to 48% this year. So, what are the reasons for this decline in public trust in the courts? Well, based on focus group interviews, our committee report explains that, quote, many believe two systems of justice exist. There's one system with those with influence, connections, and power, and another one for everyone else. For virtually all of those from minority communities, race was also seen as a contributing factor. There were complaints about the courts seeming too bureaucratic and difficult to navigate. Above all, there's a sense that courts are disconnected and out of touch with the people and local communities that they serve. Rather than providers of justice for all, courts are seen as gatekeepers of a power imbalance between the haves and the have-nots. So, what do we do to address this decline in public trust? While civics education is vitally important, the committee report says that that's not enough. As judges, we need to engage more directly with our communities and show how we're addressing their needs and concerns through innovative projects such as specialized dockets, diversion programs, and mental health initiatives. We also need to recognize that judicial independence and judicial accountability are two sides of the same coin. We must emphasize accountability and transparency in our operations and remind the public that we are subject to a code of ethics. Here in Massachusetts, we've been working to improve the public perception of our courts through initiatives that make the courts more accessible. To measure court user experience, the trial court has conducted an access and fairness survey that provides the court with an opportunity to survey court users about their experiences. The trial court's 2023 Access and Fairness Survey found that 8 out of 10 court users reported being treated with courtesy and respect, served by attentive court staff, and satisfied with their overall court experience. And over 80% of respondents gave our state courts positive ratings on most measures of access and fairness. Obviously, we're not perfect. We still have much work to do, and we need to remain committed every day to doing that work, identifying and acknowledging where we still come up short, and striving to improve. Nonetheless, we are making progress, and I believe that progress may be attributable to the fact that our courts have been doing the kind of work that's recommended in that committee report. With regard to ethics, accountability, and transparency, we have a strong code of judicial ethics that was updated in 2016 and is enforced by the Committee on Judicial Conduct and supported by the advisory opinions of the SJC Committee on Judicial Ethics. We also have a code of professional responsibility for clerks, registers, and their assistants. The vast majority of court proceedings are open to the public, and we routinely allow news cameras into the courtroom. Oral arguments before both the SJC and the appeals court are live streamed, and recordings are available online. And both appellate courts hold sittings in communities across the state so that people can come and see that work in person. We actively solicit input from attorneys and other court users, as well as court employees, about what we can do better. And we take that feedback seriously. I already mentioned that the Access and Fairness surveys conducted by the court have provided us a lot of feedback. In addition, we routinely seek public comment on rule changes. And recently, we resumed our judicial performance evaluation program after a hiatus due to the COVID-19 pandemic. Surveys have been sent out about judges in selected courts to over 10,000 lawyers and 1,000 court employees, as well as to jurors. Last year, with the help of the Flashner Judicial Institute, the SJC, and the Appeals Court, sent out a survey to over 4,500 attorneys seeking their views about the appellate process. And then we held a conference in December where 200 lawyers met with justices and staff from both courts to discuss the topics that were raised in the survey responses. And then we have taken steps to address the attorneys' requests, such as creating a database of substantive single justice opinions and contracting for the development of a more robust appellate case management and docketing system. We've also been working diligently to improve the court user experience. You'll hear more about this in a few moments, but just to highlight a few examples, the trial court is carrying out projects to provide public Wi-Fi and digital signage to make our courthouses easier to use and navigate. To assist court users who cannot afford a lawyer, the trial court provides 8 local court service centers throughout the Commonwealth, plus a 9th virtual court service center to help court users understand court procedures and fill out forms. Court service centers also provide extensive language access and computer access to those who need them. In addition, thanks to the support of bar associations and legal aid organizations, many of our courts offer Lawyer for the Day programs. And an SJC committee is updating judicial guidelines to better support judges in working with litigants who must represent themselves. Under the leadership of the Chief Justice and the Court Administrator, the trial court has created the Office of Access, Diversity, and Fairness to bring together and coordinate many different functions that affect the court user experience. The trial court has also been pursuing a new training program for all court personnel to address issues of racism and bias and support diversity, equity, and inclusion. And the SJC is continuing to convene meetings of the Chief Justices of all the courts, the Court Administrator, and the Commissioner of Probation to hold ourselves accountable for making progress in those areas. We've also created and are continuing to pursue the kinds of innovative solutions to community problems that are recommended by the Public Engagement Committee report that I mentioned earlier. For instance, we have over 60 specialty courts that focus on substance use disorders, mental health issues, and needs of families, veterans, and people who are homeless. The trial court's Project North program provides voluntary court-based recovery support navigation for eligible individuals dealing with substance use disorders, including short-term assistance with rent, in a certified sober house, and transportation to relevant services. The probation service is also doing a lot of work to help people connect with behavioral health services and social supports in the community while they're on probation or parole, or when they're about to leave or have recently left jail or prison. And we thank Commissioner Pamerson-Eifel for all of these innovative programs. And in June, we held a court-wide program for all judges based on the updated SJC standards on substance use disorders and mental health conditions that were issued last year, and we will be pursuing more training on this project. Meanwhile, another SJC committee has been working to develop a pilot program to incorporate restorative justice practices in select criminal cases, giving victims and their communities more of a voice in shaping what offenders must do to repair the harm that they've caused. I believe that all these initiatives are making a difference, and I look forward to continuing the work with all of our internal and external stakeholders. I also look forward to discussing this work and other topics this afternoon with President Santoro, Chief Justice Brieger, and Court Administrator Ambrosino. Thanks.
Thank you so much, Chief Justice Budd. What a way to start. So, as I mentioned before, our program is now going to pivot to a panel discussion with these 3 incredible court leaders that we have here today. We are now in the 3rd year of this format, which we feel provides a greater understanding of what our courts are doing and what is coming up next for our judicial leaders. So before we jump into the questions, it is now my pleasure to introduce our other 2 panelists. First, Chief Justice Heidi E. Brieger was appointed Trial Court Chief Justice by the Supreme Judicial Court effective December 22nd, 2023, almost 2 years ago. 1 year. The Chief Justice of the Trial Court is the policy and judicial head of the trial court. Chief Justice Brieger was previously Chief Justice of the Superior Court since June 2021. She was originally appointed to the Superior Court by Governor Deval Patrick in 2012. She later served as the Regional Administrative Justice for Civil Business in Suffolk County and chaired the Superior Court Education Committee. Prior to her time on the bench, she was a longtime member of the U.S. Attorney's Office in Massachusetts, serving as an AUSA from 1992 until her elevation in 2006 to Chief of the Organized Crime Drug Enforcement Task Force. Known for her collaborative leadership style, which I can certainly attest to with the Lawyer for the Day program, she is absolutely ideal in her current role as Trial Court Chief Justice, which leads side by side with the court administrator. Welcome, Chief Justice Brieger. And last but absolutely not least, as anyone in the room would agree, I am so pleased to introduce our final panelist, Thomas Ambrosino, who has been our court administrator of the trial court since January 2023. Mr. Ambrosino is responsible for all of the trial court's administrative functions, including budget preparation and oversight, labor relations, information technology, capital projects, and personnel policy. Together, Chief Justice Brieger and Mr. Ambrosino oversee more than 6,000 court staff and 94 courthouses across the Commonwealth. Mr. Ambrosino previously served as city manager in Chelsea and was formerly the mayor of Revere for more than 10 years. Many of us also know him from his previous role as executive director of the SJC at the time when the trial court administrator role was initially created. He is well-versed in the needs of the court and also known as a successful collaborator. And welcome, Mr. Ambrosino. So we'll jump straight into it today. We have one microphone, so I'll be moving back and forth, as will our panelists. The first question is for Chief Justice Brieger. Chief Justice, what specific strategies are being implemented to improve case management efficiency in the probate and family court and juvenile court? And how are these efforts addressing current challenges and ensuring timely resolution of cases?
Thank you very much, Madam Chief Justice. Thank you for having us to share the pleasure of bragging about the judiciary for just a few minutes. Let me just say that the specifics about case management and timely resolution that I am going to address that deals with the probate and family court and the juvenile court are just as important for the other courts as well. But these are programs that we have taken up to address some, I've now learned the word, pain points in the practice of juvenile court and probate and family court. And we have the cooperation and steadfast support of the chiefs of those courts, Chief Justice Casey and Chief Justice Gershengorn, both of whom are fantastic leaders and have done a lot to make some of these changes a little bit easier. Starting with the probate and family court, one of the things that we're trying to do is expand the use of their Pathways docketing program, which tries to identify cases early on for an early resolution. And they've had enormous success with this. And I think what they've done is taken a lot of cases out of the courtroom and into the clerk's office and the judicial case management route so that they can identify ways to find a resolution that doesn't involve court hearings and evidence finding. And they're doing quite a good job with that. They're also starting a pilot in Norfolk County to do something that I think is really critical, and that is have a trial week every week of the month in Norfolk County, so that there will be a judge assigned to do nothing but trials all day long for a week. And that means that some of the trials that have languished because there wasn't a judge to handle them, because there was the press of other judicial business, will be taken off those judges' dockets, and those judges will be assigned specifically to trials. We need to get trials started and finished, and that is one of the goals of that pilot program. I very much hope that we're going to expand that throughout the Commonwealth, and I think that will have enormous positive effects for the probate and family court. They've also worked on a standing order that's already been promulgated that will require cases to be, trials to be started and then have a next date and hopefully a conclusion within 30 days. That is wildly revolutionary and I think critically important to moving cases through the system. In the juvenile court, they, in addition to suffering from some significant vacancies, which plague the trial court throughout and which have been the subject of much lobbying on Beacon Hill and with the governor's office and the Office of Legal Counsel, we've done everything we can to support their ability to give us new judges, and I know they're working very hard on that, but we need more faster. But one of the things that we're doing in the juvenile court is trying to assure that trials happen on consecutive days instead of on one day and then in 6 weeks and then in another 6 weeks and then in another month. So sometimes juvenile court cases can take up to 18 months to conclude. That's not good. And there are going to have to be some changes. They've adopted and are about to propose to the Supreme Judicial Court some rules that will address this issue, suggesting that trials happen presumptively on consecutive days or days quite close to each other. I think that's going to have an enormous effect on the efficiency of the juvenile court. There is also, I think, a need, because the juvenile court is, as many of our courts, a community court. They often are operating in courthouses with only one judge. That does not permit trials to happen on consecutive days as easily because there are so many emergency matters that need to be handled immediately, which causes trials to be recessed briefly, sometimes not so briefly because of lawyers' schedules. So we're going to try to adjust our assignment program and practices for juvenile court judges so that there are not any courthouses that go for long periods of time with only one judge. This is a practical solution that has enormous political consequences and also enormous consequences for changing culture, and we're doing that slowly. It's important, and I am with those chiefs all the time to try to support them in making these changes, but I think they'll be very effective once they're adopted.
Thank you so much, Chief Justice. The next questions are for Court Administrator Ambrosino. The new court IT bond bill appeared to allocate funding to make the courthouses in the Commonwealth more accessible to the public. Please let us know what items will soon be or have been announced to facilitate in these efforts. And if you could please also, let us all know, when will courthouses and courtrooms be Wi-Fi accessible?
Thank you very much. So I can say that the work we've done so far under the IT bond bill has helped improve public accessibility, and there's more to come. So let me explain. The IT bond bill approved by the legislature and signed by the governor took place in August of 2022. So we're about 2+ years into this effort. And we started and have spent most of the first 2 years in that effort in rebuilding our network infrastructure. Our CIO, Steve Duncan, often jokes to me that prior to the bond bill, Our major courthouses, even major court complexes like Worcester, had as much capacity for the network as you have at your home with your one Comcast line coming in. And you can imagine what that meant when we have hundreds of employees in that courthouse trying to access the internet, plus judges trying to do remote hearings. It wasn't pretty. So we've spent most of these first 2 years rebuilding all of that infrastructure, rewiring all of these courthouses, improving our service. We are just about done with all of that network upgrade. In fact, we have finished every courthouse but one, Gloucester District Court, and the only reason we haven't finished that is because it's still under reconstruction. So that has allowed us, that has provided the basis for us to do what I'd say are three things already that have improved public access. The first is what Victoria mentioned, Wi-Fi. We now have been able to, once the network's in place, provide robust, active, really high-speed Wi-Fi. We have completed that as of today in 73 of our 94 courthouses. We expect the remaining number to be done no later than March 31st, probably with one or two exceptions. The exceptions, unfortunately, being this building, the high-rise next door, and Lawrence Superior Court. And those three would likely be done by June. And the only reason there is that delay is because in some of these real old buildings, doing wiring through the walls gets very complicated. And so those three may extend beyond March, but we expect all the other courthouses to be done. And right now, you can walk into 73 of them. You've got high-speed Wi-Fi. That really helps the public, particularly our jurors love it, visitors to the courthouse love it, lawyers love it, because now they really can access Wi-Fi in their downtime or if they're looking to do something while they're in the courtroom. So that's one thing that's happened. Second, we now have the capacity to do a lot more remote hearings. We are no longer constrained by our infrastructure to do remote hearings. So judges now have at least the opportunity to do it. The network is no longer constraining that. There may be policy reasons why a particular hearing will not be remote, but our network is no longer an excuse for that. And the third thing that the new networking that we've already done has allowed us to do is start our digital signage program, another effort that really improves public accessibility, because our goal is to have digital signage in every one of our courtrooms so people that walk in can actually know where they're supposed to go, where their courtroom is, and then outside a courtroom see exactly what cases are on in that particular courtroom. We have completed that digital signage. Our first courthouse is done. That's Chelsea District Court. We will now roll this out to every one of our other 93 courthouses over the course of the next 3 years. And the first bunch of additional courts, another 8, are expected to start in the early part of 2025. The third thing that, so those are 3 things that right now we are doing. I expect 3 more things in the near future that will help with public accessibility and is all part of this bond bill. First is online dispute resolution. That is something we are rolling out as a pilot in the early part of 2025 in 3 courts, Waltham District Court, Chicopee District Court, and the Brighton Division of the BMC. That will start for small claims cases where we will have online dispute resolution for our litigants. In addition to that, we are embarking on a collaboration with Suffolk Law School on a guide and file effort. This is like a TurboTax situation where particularly self-represented litigants can go online, they can answer some questions, and what will be developed is a pleading in exactly the format that we need, and they can press a button and it'll be automatically e-filed. We are starting that with small claims cases, and our goal is to utilize that effort for eviction sealing, which by the legislative mandate must be in place for us by May the 5th of 2025. So that is another place where we see a great improvement for public access and access to justice. And the third thing I would say is our goal that is in the near future is to put more and more of our information, have it publicly available online, so you don't have to come to the courthouse to get publicly available information. We are going to start by trying to get all of the information currently on our public kiosks available on the internet, so you don't have to come in to the public kiosk to do work. Whatever is there, we hope to have online, and that is a project we're going to work on during the course of 2025. There are some technological issues that we need to overcome, but with this network upgrade, we feel confident that we'll be able to do that. And so those are just 3 things in the future that are coming as we continue to implement the bond bill. Remember, this bond bill was always a 5 to 6 year plan to become a digital court. I feel we're pretty much on track for that, but we're only 2.5 years in, so much more to come. Thank you.
Thank you, Mr. Ambrosino. I know most of these changes are directed towards the public, but as a practitioner, and I'm sure on behalf of many practitioners, both in terms of case management resolution and the updates to the courthouses, we can certainly feel them and appreciate them. So thank you. Our next question is for Chief Justice Budd. Last week, the SJC issued eagerly anticipated amendments to the rules on criminal pretrial discovery, Rules 14 to 14.4. Can you please tell us a little bit about that?
Yeah, thank you for that question, because it's not often that we issue press releases when there are rule changes, so you have a sense of the importance or how we see these rules in particular. Back in 2018, the SJC issued CPCS versus the Attorney General, and part of that opinion asked our Rules Committee, our SJC Advisory Committee on the Rules of Criminal Procedure, to provide a detailed checklist for prosecutors to identify the most likely sources and types of exculpatory information, or otherwise known as Brady material, that has to be turned over to the defendant. And that committee worked for many years, and in 2022, they published proposed amendments to Rule 14 for public comment. There were a lot of comments received, reviewed, revisions were made, and earlier this year, the committee presented proposed amendments to the SJC. By order, the SJC approved them, and they were released last week. The biggest change, I'd say, is that new Rule 14 first of all, it updates the language that we use. We used to call it exculpatory information, but really we're talking about any information that would be favorable to the defense, not necessarily exculpatory, but favorable. And it provides examples, a non-exhaustive list of the types of items and information that should be disclosed. The new rules will take effect on March 1st, 2025. It'll give practitioners, the defense bar, prosecutors a chance to become familiar with them. And we hope that this rule will help prosecutors in meeting their constitutional pretrial discovery obligations. I just want to take a second to thank the committee chaired by Superior Court Associate Justice Beverly Cannoni, and the entire committee. They really did a lot of work to get these rules together. And I should also note that the reporter's notes that were issued with the amendments, while they're not endorsed by the court as per usual, I think that that practitioners will find these notes very helpful as they figure out how to navigate the new rule. And so I want to thank the reporter for the SAC Criminal Committee, Professor David Siegel of New England Law. So that's what to expect.
Thank you. And our next question is directed towards Chief Justice Breger. The Land Court is developing a pro bono panel of attorneys to assist in tax foreclosure cases. Would you be able to provide the parameters of this new effort?
I would be so happy to. This is a complete home run for the Land Court, and I would like to first off thank Chief Justice Piper, Judges Foster, Rubin, and Resnick for all the work they did. This is a long time coming. Judge Resnick became a judge during the course of the time this was in the works. This is a fantastic lawyer referral program for a group of folks who desperately need legal assistance. If you're not familiar with tax lien foreclosures, and many of us are not, when folks do not pay their taxes or they don't pay their utility bills, their property can be taken by the municipality or the state, depending, and it leaves people homeless. It leaves families broken, and it takes people who were sane and turns them not quite so sane. And they often don't have the wherewithal, either financially or educationally, to hire counsel to help them through this process. And this program is directed to those people. It is a partnership with the Clearinghouse for Access to Justice Fellows. It is also a partnership with the bar, the real estate bar, and others, and also the judges in the Land Court. I can't tell you how successful folks are who have evaluated this. It has grown. There are more than 40 cases and matters now that are staffed by legal representation that is completely voluntary. This is the place where the bench needs the bar. And in order for us to do our job well, we need members of the bar to volunteer their extraordinary extra time and their extraordinary talents to assist us in assisting those who can't help themselves in this area. There will be a tax lien foreclosure legal assistance training webinar. And right now I am making a shameless plug for those of you who have some extraordinary time on your hands to help out. And that is going to be an MCLE webinar on February 7th from noon to 2. And if you can help, even if it's just to take one case, that one family will be eternally grateful.
Thank you so much, Justice Brieger. Our next question is directed toward Court Administrator Ambrosino. The safety and welfare of attorneys and judicial employees is very concerning to the bar both in Massachusetts and in other jurisdictions. We have been fortunate in the Commonwealth to avoid any of the violent instances that we have seen in other jurisdictions. However, are there any new measures being considered to bolster security measures for all court users in the state of Massachusetts?
So obviously, given the state of the world and recent events, this is a major concern, not just to members of the bars, but for our judges, our clerks, our own employees. We are doing two things to improve security. So first, as part of the bond bill that I mentioned previously, we are upgrading the physical security in every one of our 94 courthouses. That means for each of these courthouses, new cameras, new keyless entry, duress alarms, better communications, better screening. We are doing that in every courthouse as part of our bond bill. So far, we started this this calendar year. We've completed 7 courthouses. We've got another 18 planned for calendar year 2025, and we will finish the remaining balance of our 94 courthouses over the course of the ensuing 3 to 4 years as we complete work on this bond bill. So that major physical upgrade is something that's going to be very helpful to us. It's certainly going to be time-consuming, and it's quite expensive, but our goal is to complete every one of our courthouses. The second thing we've done is to increase our contingent of security officers. So we now have a security department that has an authorized figure of personnel of 1,050. That's the highest number we've had since COVID, and about the highest number in the last decade. We are trying to continue to increase hiring of court officers. So now I'm going to do my own shameless plug. We actually have a court officer exam coming up. So if you know anyone interested in becoming a court officer, I strongly encourage you to encourage them to apply. The deadline for applying for that January exam is this week, December 15th. So if you know anyone interested in becoming a court officer, a wonderful job in the trial court with good pay and great benefits, I ask you to encourage them to apply. Thank you.
Don't go too far. I've got another one for you. Court Administrator Ambrosino, what efforts are underway to address capital planning and improve courthouse infrastructure to better meet the needs of court users and staff?
So I'm going to break this into two parts. So first, we have many old court buildings. We actually were able to convince, and we got great support from both the legislature and Governor Hill and Lieutenant Governor Driscoll, to get approval for 4 brand-new courthouses in the capital plan. Those are new courthouses that will be built over the ensuing 5 to 7 years. That is a new Quincy Justice Center, a new Framingham Justice Center, a brand-new renovated Lynn District Court, and a new Springfield Regional Justice Center. That's about $1 billion worth of construction. Those 4 buildings, the design for all of them is ongoing, and we expect Quincy and Lynn to start probably sometime in 2026, and the others to follow closely behind that. That's probably all the new construction we'll be able to get done for the next 5 to 7 years. In addition to that, though, we also get from DCAM about $9.5 million each year to do deferred maintenance on our other buildings. We supplement that with about $10 million of our own operating budget. So we do about another $20 million plus of facilities work in all of our remaining 94 courthouses. We probably have $60 million worth of deferred maintenance to do, so we do have to prioritize each year what we're doing. But the bottom line is, in addition to the 4 new court buildings, we invest every year a significant amount of money to keep our courthouses up to snuff. Some are quite old, as practitioners know, but we do our very best to keep them well-maintained.
And our last question will go towards Chief Justice Budd. There have been a number of departures and arrivals amongst justices, clerks, and other senior leadership positions at the courts. Can you go over some of those for us?
Sure, I'd be happy to talk a little bit about some of the comings and goings over the past year. The SJC, of course, has had some major transitions. Justices Elspeth Seifer and David Lowy retired earlier this year. And between them, they had nearly 50 years of judicial experience. So they're missed, but I have to say that we were able to welcome Justices Bessie Dewar and Gabrielle Walahojian to succeed them, and they each bring a wealth of experience themselves. We're thrilled to have them. Justice Dewar, having served for years as state solicitor in the Attorney General's office, she supervised the briefing and arguing of appeals by attorneys throughout the office in state and federal courts, and also supervised the amicus brief practice amongst her other responsibilities. And then, as many of you know, Justice Walahojian has been on the appeals court before she came to us. She had been there since 2008, so she had many, many years of appellate experience and leading committees that were focused on rules, policies and procedures in the courts and has been very eager to help us here at the SJC. Also, with regard to the SJC, we have some changes in our clerk's offices, as you may know. Longtime SJC clerk for the Commonwealth, Fran Keneally, is now a district court judge, and he is succeeded by Maura Looney, who is now our clerk for the Commonwealth. And she served in the assistant clerk role for 11 years, so she is well-versed in what we need in that office and is doing a great job. And then the SJC clerk for the County of Suffolk, which is an elected position, you may well know that Clerk Maura Doyle is retiring at the end of this year after holding that position for 28 years and will be succeeded by newly elected Clerk Allison Cartwright, who will be joining us from the Committee for Public Counsel Services, where she was the Managing Director of the Public Defender Division's Central Region. And before that, she served as Assistant Corporation Counsel for the City of Boston and was in private practice. She'll be our first African-American woman to hold that position as clerk. We've also had some major transitions in the appeals court. We have a new Chief Justice there. Amy Lynn Blake was recently appointed to succeed Chief Justice Mark Green, who retired after 23 years on the appeals court and 7 years as chief. Chief Justice Blake is also a very experienced jurist, having served 10 years on the appeals court and 6 years on the probate and family court, and she's the first woman to lead the appeals court. And the appeals court also has appointed a new clerk, Paul Tuttle, who succeeds Joe Stanton. And you heard about some of them already, but we have several new chief justices in the trial court since last year's State of the Judiciary, including Trial Court Chief Justice Heidi Brieger, Superior Court Chief Justice Mike Ricciuti, Boston Municipal Court Chief Justice Tracy Lee Lyons, and Juvenile Court Chief Justice Dana Gershengorn. But this is how all organizations work, right? You have people leave and you have new people come in. We regret losing the experience and the friendship of the people who have left us, but we welcome their successors who are experienced in their own right and bring fresh perspectives. And I just want to emphasize how proud I am of the judges and the court employees who work in our state court system. I am proud to be a part of this system. I'm honored to be able to lead the system and feel very lucky about where we are and where we're headed. So, thanks.
Thank you so much to all of our panelists. One of the things I hope we all learned today or reflected upon today perhaps is that the administration of justice is not easy. It is a foundational component of our country and also our state here in the Commonwealth. And the three people who spoke today are illustrative of the determination and the talent and the heart that is within our leaders, but also within all of our judges and court staff throughout this Commonwealth. So when we hear about all the things that they are doing, I am just so proud and privileged to work for all of you. And thank you for all that you do every day. We have Court Administrator Ambrosino, who is working every day to modernize, improve, and make safer the courthouses that not only we as practitioners, but also the public in the Commonwealth use every day. We have Chief Justice Brieger, who last year helped champion our Lawyer for the Day program in the Superior Court, and with no time to be wasted, talked today about another pro bono program she's leading. And we have our fearless leader, Chief Justice Budd, who I've looked up to for so many years, working every day to make the administration of criminal justice at the SJC even better in this state. Thank you so much. I say again, the administration of justice is not easy, and on behalf of the Massachusetts Bar Association in my role there, but also in my role as a practitioner and a citizen of the Commonwealth of Massachusetts, thank you for all that you do. We'd like to invite everyone attending here in person today to the Thorndike Library for some drinks and refreshments, and thank you all for attending.